A court does not operate according to any true rule of law but rather by presumptions of the law. If these presumptions, presented by the private bar guild, are not rebutted, they become fact and are therefore said to stand as truth in commerce. Below are the 12 key presumptions asserted by private bar guilds. If unchallenged, these presumptions are considered true. 1. The presumption of public record. The presumption is that any matter brought before a lower Roman court is a matter of public record. However, it is presumed by members of the private bar guild that the matter is a private guild business matter. Unless this presumption is openly rebuked and rejected, by clearly stating that the matter is to be on the public record, the matter remains under private bar guild rules. 2. The presumption of public service. This presumption asserts that all members of the private bar guild, who have sworn secret oaths to their guild, act as public agents or officials of the government. They also take additional oaths of public office, which often contradict their superior private oaths to the guild. Unless openly challenged, the claim stands that these private bar guild members are legitimate public servants and trustees under public oath. 3. The presumption of public oath. The presumption holds that private bar guild members, acting as public officials under a solemn public oath, are bound to serve honestly, impartially, and fairly. If not openly challenged and questioned, the presumption stands. If challenged, these individuals must recuse themselves due to a conflict of interest. 4. The presumption of immunity. The presumption claims that members of the private bar guild, acting as judges, prosecutors, or magistrates, are immune from personal liability for injury caused by their actions. Unless this presumption is openly challenged, the guild members remain immune from accountability. 5. The presumption of summons. By custom, a summons that is unrebutted stands. Therefore, attendance in court is presumed to signify acceptance of a position, such as defendant, juror, or witness, and the court's jurisdiction. Unless the summons is formally rejected and returned, the presumption of guilt stands. 6. The presumption of custody. This presumption holds that a summons or warrant for arrest, if unrebutted, signifies that the individual is a thing and liable to be detained by custodians. Unless openly challenged, the court assumes the person is property and subject to custody. 7. The presumption of the court of guardians. If you are listed as a resident or ward of a local government, you are presumed to be a pauper under the guardianship of the court. Unless openly challenged by asserting your role as a general guardian and executor of the matter, the presumption stands, and you must obey the rules of the court of guardians. 8. The presumption of the court of trustees. It is presumed that by attending court, you accept the role of trustee and public servant. Roman courts operate under the assumption that all participants are public trustees. Unless this presumption is explicitly rebutted, jurisdiction is assumed simply by your appearance. 9. The presumption of government as executor/beneficiary. This presumption claims that the judge or magistrate acts as executor, while the prosecutor acts as the beneficiary of the trust related to the case. Unless you assert your position as both executor and beneficiary of the matter, the presumption stands that you are the trustee, subject to the executor's authority. 10. The presumption of executor de sun tort. If you attempt to assert your rights as executor and beneficiary of your body, mind, and soul, it is presumed that you are acting as a false executor. Unless you question the judge's position and assert your own, the judge or magistrate assumes authority as the true executor, with the right to penalize or detain you. 11. The presumption of incompetence. This presumption holds that you are ignorant of the law and, therefore, incompetent to represent yourself. Unless you actively rebuke this presumption and assert your role as executor and beneficiary, the court assumes you are incompetent, allowing the judge or magistrate to take necessary actions to maintain control.